Okay, I'm going to jump right into my own outline of civil procedure casebook, and it begins with personal jurisdictions, the historical origins and traditional bases of personal jurisdiction. Begin with Penn-Neuer's two-pronged holding. The appeal court reversed the trial court's application of state statutes allowing newspaper service to relay seizure of real property in the state of California, I believe, or Washington, as satisfactory for justice to render binding judgment on out-of-state defendant. The appeal court interprets the due process clause to require personal jurisdiction to give full effect to full faith and credit of its judgments and laws while balancing state sovereignty. Therefore, the case holding is that a valid personal jurisdiction requires in-state service, which is presence, to his consent, or which is by appearing. So that's your holding from Penn-Neuer. I don't know the exact date of this case, but it's going to be an early one. Presence is further broken, it's defined as in-state service, but examples: transient tag jurisdiction or presence in that state. And third, traveling was a purposeful action. Consent is the other prong for personal jurisdiction at the time of Penn-Neuer, which is voluntary appearance and consists of appearance in court or having one's agent appear in court, answering a complaint, and extraction, which I have meaning that an agent accepts. Service of process, more likely than not, is what they accept. Then the next case in a series of historical cases is Hess from 1927, holding that stretches consent to embrace implied consent by service through an appointed agent. So if it wasn't already the case, it is certainly now after the Hess holding in 1927. Then agent acceptance bears implied consent. Presence is strike through over foreign corpse, presence inferred from corp doing business within the state. But the rule from the Hess case is that a Massachusetts long arm statute allowed a defendant, PA resident causing harm to MA resident in out-of-state accident, to be served to his attorney by registered mail with the same legal force and validity as served on him personally. The holding is the advent of the notion that a non-resident could do something within a state that gives that state personal jurisdiction over the non-resident. The following seminal case is International Shoe. This sets forth the modern personal jurisdiction doctrine. The rule is to exercise personal jurisdiction over non-resident. She or he must have certain minimum contacts. With the forum state such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. Minimum contacts and exercise of personal jurisdiction is fair and reasonable. Jurisdiction depends on the nature of the contact, which is deemed from the claims asserted. Minimum contacts analysis, see table below. Nature of contacts, continuous and systematic, or isolated and sporadic. State contacts related to related or unrelated to the claims in the action. Distinction between specific jurisdiction and general jurisdiction. By way of a table in my outline here, shows those two factors as rows in the grid, where continuous and systematic. If yes, then jurisdiction is proper in both specific and general columns. So specific jurisdiction, general jurisdiction columns. If the contacts are proper, if contacts are substantial, is kind of the added note for general jurisdiction. When second factor, isolated and sporadic, is considered for specific jurisdiction. It depends on the nature, quality, and context of the contacts for there to be proper jurisdiction. For the general jurisdiction column, isolated and sporadic would not produce jurisdiction, proper jurisdiction. Now, after the Volkswagen case, there's another factor to consider for specific jurisdiction. That is, if purposeful availment and reasonableness requirements are satisfied, then you can find specific jurisdiction. And furthermore, after the Asaki case, there's another factor to consider. I just haven't written anything in a specific or jurisdiction column, but I will say that there's probably nothing in the general column, but there's likely something in the specific jurisdiction column. I've got to get there. I know the Asaki cases. Asahi Metal Industry Company versus Superior Court. Tires were manufactured, sold, and sent from Japan to China to enter the stream of commerce, but the manufacturer was not aware that the purchaser would market and sell the tires in the form state of California and therefore lacked foreseeability. Therefore, there's no jurisdiction over Japanese company in the indemnity case brought against it when there was a tire blowout resulting in the death of somebody's driver's girlfriend or something. And there's like 3 tests that came about out of this from different Supreme Court justices. So there's one, the O'Connor test, the Brennan test, and there's a general rule. So firstly, the general rule, the defendant's minimum contacts in form state must derive from the defendant's action purposefully toward the form state. So the purposeful availment was already brought into the analysis in Volkswagen, which we'll get to later. But I want to say this is probably the stream of commerce consideration. Under the O'Connor test, an intent to serve the forum state specifically and conduct evidencing that intent. Multiple choice questions should include O'Connor test, which is accepted. The Brennan test is that the awareness of the final product is being marketed in the forum state. Then there's reasonableness factors still proceeding from this case, which is burden is on the defendant to prove personal jurisdiction on the defendant, interest in the forum state, plaintiff's interest in obtaining relief, interstate judicial system's interest in obtaining the most efficient resolution of controversies, and the shared interest of the several states in furthering fundamental substantive social policies. So, grab a pen quickly and just write down that I think that the Asahi factor is going to be like intentional entry into stream of commerce in forum state produces personal jurisdiction. Oh. All right, so let's keep moving. We're through that lovely table for determining between when general jurisdiction is proper and specific jurisdiction is proper. There's a little bit of a way to approach that in an essay question. And in fact, they've got general jurisdiction just plainly said as when the defendant is at home in the jurisdiction. Informed state makes the IPJ proper. That could be yet another factor, but I'm writing that down. But for everything else is essentially specific jurisdiction. General jurisdiction is only going to come about if it's like a systemic or continuous contact in the forum state, as long as that those contacts are substantial. Everything else has to come in under specific jurisdiction, which can sometimes apply in isolated and sporadic contacts if they're related to the cause of action that's being brought. So it depends on the nature, quality, and context of the contacts. After the Volkswagen case, there's purposeful availment and reasonableness requirements. After Asaki, there's the intentional entry into the stream of commerce in the forum state. As I talk a lot, I think that there's if the defendant should reasonably be expected to be hailed into court in the forum state. I want to say that comes from Burger King, but I'm going to just have to keep reading through the essay to figure that out. But I will write a few notes here. Hailed into, okay. All right, so on specific jurisdiction and minimum contact section, specific jurisdiction is a minimum contact analysis, and basic base analysis involves purposeful availment and foreseeability. Foreseeability may be otherwise said as being hailed into court. If you can foreseeably be hailed into court in the jurisdiction for your contacts in that jurisdiction. We'll figure out which case that comes from shortly. The distinction between statutory authority and constitutional authority for exercise of personal jurisdiction over non-resident defendants. That's a distinction made under state long-arm statutes, which is, part one of the specific jurisdiction and minimum contacts analysis. So first are state long-arm statutes, which are either going to enumerate the types of cause of actions that are going to exercise, going to be able to give the state the power to exercise personal jurisdiction over a defendant. And then some states, long-arm statutes, go to the, extend personal jurisdiction to the extent of what authority there is under the Constitution, which I want to say is fair play and substantial justice. So I just said that in my own words just because I know that I was struggling with what long-arm statutes were at the time that I wrote this outline. Those that exercise personal jurisdiction to the constitutional limit or are interpreted to do so do not engage in the two-step inquiry. It's one-step constitutional under the federal standard. Whereas in the long-arm statutes that enumerate offenses, let's just see, what is the two-step? So enumerated long-arm statute means that the states exclude enumerated claims from clogging their judicial system. Exclude or specifically include, it depends on the state. And those that authorize personal jurisdiction to the constitutional limit. Okay. So I think the analysis is going to be, what was the cause of action? And is it enumerated in the long-arm statute? And then, yes, you have IPJ. No, you don't. Anyhow, let's move on. Constitutional authority for personal jurisdiction and minimum contacts. The McGee case and the Hansen case and the worldwide Volkswagen versus Woodman case and the Kolko versus Superior Court case and the Keaton versus Hustler case and the Calder versus Jones case and the Walton which considered within it, I don't think they're supposed to be separately holding on the constitutional authority and minimum context question, but I think within the Calder versus Jones case, they considered Walden versus Fiore, Schwarzenegger versus Ford, and Feelings versus Hubert. All right, and that's looks like it's then furthered by the Burger King case, which gave us Brennan's reasonability and fairness test, followed by the Ashi case I already read about, and then J. McIntyre Machinery, which is an extension of Ashi. Oh my God, Bristol Myers Squibbs also bears on this constitutional authority for personal jurisdiction and minimum context analysis, and that will be the last case that builds on constitutional authority for personal jurisdiction and minimum context, and then we'll transition into specific jurisdiction. And minimum contacts mainly go into internet contacts, contemporary approach. So I'm going to cite these cases. I'm just going to read about these cases, take each one in turn, knowing that they build upon and expand upon what is constitutional authority for personal jurisdiction, mainly defining minimum context within that context. And so for McGee, the consideration of the forum state's interest in providing a forum for resolving the suit, interests of claimants, inconvenience to defendant, and location of witnesses. Maintenance of premium payments via mailed check payment is sufficient minimum context. So this was an insurance case. Payments were being sent to another state, and the acceptance of the check gave enough sufficient minimum context for personal jurisdiction to be found in the state of the payor of the check, which I think was California, mailing checks Texas, but I'm not sure why I think that many years after reading it. The Hansen case is the next case in this bunch. And this is Wilmington Trust acts as the trustee of a trust opened for a resident of Pennsylvania that moved to another state and modified the trust in the other state, which I believe is Florida. And the holding was that the state in which the modification occurred in Florida should try the case according to their laws, not Delaware's laws. And why? The rationale was that the cause of action did not arise from an event that occurred in the forum state. The emphasis on the state connection with the dispute and the defendant's purposeful availment. That case was actually really interesting because it's a PA resident who wrote a trust in Delaware and moved to Florida where she died. So a lot of the question, which I didn't put this fact in here, is where was the trust registered or being executed? If it was in Florida, then they want to defer to Florida. If Delaware, then perhaps Delaware law. So that is a really interesting case, but where they landed was Florida, but why? Because that's where the modification occurred. That's like the most recent action in the timeline. And then the rationale again is that the cause of action did not arise from an event that occurred in the forum state. I think they tried to bring a case in Delaware over some matter in the trust. And the emphasis on the state connection with the dispute and purposeful availment was their way of arriving at that state choice of law, choice of forum. Worldwide Volkswagen versus Woodson is a much more important case, actually. There's a lot to read here. I've written the issue, the analysis, the holding, where we get to the minimum context analysis. So before, which is what's highlighted, this case really stands for the issue, the upstream importer dealer situated in New England enjoined with a foreign car manufacturer to answer in product liability case for harm suffered in maybe Oklahoma, by a purchaser who bought the car in her then home state of New York, but put the car into another state while relocating to Arizona. And so the analysis is following the reasonableness test, whether it's inconvenient to defend oneself in another state, but not an offense to notions of fair play and substantial justice. Product is so mobile by nature, it is reasonable it would be used and consumed in another state. However, minimum context is too attenuated. While the car is mobile, the defendant gains no economic benefit from the foreign state. Unilateral action test. Minimum context must be based on an act of the defendant, not just the plaintiff. Unilateral action test. The holding, the foreseeability that is critical to the due process analysis is not the mere likelihood that a product will find its way into the forum state. Rather, it is that the defendant's conduct and connection with the forum state are such that she or he should reasonably anticipate being hailed into court there. So this is the hailed into court, foreseeability. case. It didn't, I don't get the sense that it worked in the dealer's favor, or that it did. So they're stating the test as the reason why they didn't find a jurisdiction in Oklahoma, I think, or wherever this case was being brought. Now, that was a holding. The foreseeability that is critical to the due process analysis is not the mere likelihood that a product will find its way into the forum state, rather is that the defendant's conduct in connection with the forum state are such that they would reasonably anticipate being hailed into court there. Now, for the minimal context analysis applied in this case, two branches with many factors. A, the sovereignty branch, B, the convenience branch. The connection between, under the sovereign branch, the connection between the defendant and the forum state. 1, no personal jurisdiction, where defendant has no contacts with the forum state. 2, defendant must purposely avail himself of the privilege of engaging in activity within the forum state. 3, minimum contacts must be based on the defendant's act. And D, defendant can reasonably anticipate being hailed into court there. That's basically the analysis. Part 1. The convenience view emphasizes the reasonableness of asserting personal jurisdiction based on several factors. 1, the burden on the defendant. Once the plaintiff proves that defendant purposely availed himself of the forum, the defendant must prove the personal jurisdiction works an unreasonable burden. The state's interest in adjudicating the dispute. The plaintiff's interest in obtaining convenient and effective relief. The interstate judicial system's interest in obtaining the most efficient resolution of controversies, and the shared interest of states in furthering fundamental substantive social policies. So these fairness factors, I mean, this is really what the essay is looking for when you consider if personal jurisdiction is fair. So you've got burden. I'm just going to write fairness, convenience, fairness. Burden on defendant, state interest, plaintiff interest, and then judicial system interest. Those are your factors for if I got them memorized correctly to consider. Also coming from the Volkswagen case, apparently. So, I also just wound up there in my outline. Came from somewhere else. Let's keep going. Holco versus Superior Court introduces an effects test, where a non-resident defendant has caused an effect in the state by an act or omission outside the state, the personal jurisdiction over the defendant in cases arising from that effect may be exercised whenever reasonable. Distinction between contacts arising from personal domestic relations compared to a commercial transaction for defining what is purposeful availment. In this case, which might have been more important to put up front, is that this is a custody child support action considering a state interest when the father acquiesces to his child being in the forum state, is it too attenuated to ask the father to defend himself in California when the act doesn't cause injury, is not of a commercial nature, meaning there's no purposeful availment and lacks foreseeability? And for the personal action, this does not constitute minimum context. So it's an effects test, and it hinges on it's premised on that personal action isn't going to constitute minimum context if you're talking it has no commercial nature, therefore there's no personal availment, and thus it lacks foreseeability. So Keaton versus Hustler is going to be a short case holding the magazine purposely availed itself to the New Hampshire market by selling 15,000 copies, which harmed the editor's reputation among her community, which she was a New Hampshire resident at one time. So behind the scenes, very few states' long-arm statute, I guess, allows defamation, or at least that's what I recall reading from this case. Now, because the editor had at one point lived in a state that did have a long-arm statute protecting her reputation in New Hampshire, and once lived in New Hampshire, then she was really forum shopping for an action against Hustler's depiction of her in the magazine, and used the sales in that particular market to meet purposeful availment as well in that market, and brought the case there, got jurisdiction there. Calder versus Jones is another newspaper case, somewhat the same premise. The facts are that California finds personal jurisdiction of Florida newspaper that wrote a piece on a California resident. How the analysis is that the defendants who intentionally direct wrongdoing at a state may reasonably anticipate being hailed into court there. The effects test appears to permit personal jurisdiction over the defendants committing intentional torts directed at the forum state. Although each state's iteration is different. While a pattern of practice, no more than one isolated article, was not established, the defendant is still subject to personal jurisdiction for purposeful availment and foreseeability. The defendant ought to know injury could be caused in California by the conduct, and that, in effect, it is reasonably foreseeable that the newspaper may be hailed into court there. Walden versus Fiore limitation: the mere injury to a forum resident is not sufficient connection to the forum state. So mere injury to a forum resident is not sufficient connection. There must be some knowledge of plaintiff's connection with the forum state and potential that plaintiff will suffer harm there, coupled also with a tortious and I think intentional tort, to be specific. Intentional tortious action by the defendant. Schwarzenegger versus Ford, a harmful act and tortious conduct must be expressly aimed at the forum state with knowledge that the plaintiff is likely to suffer harm there. That's like saying the same thing I just said in the Walden versus Fiore case. Fieldings versus Hubert, harmful act, tortious conduct must be expressly aimed at the forum state with knowledge that the plaintiff is likely to suffer harm there. So that's the exact same case. So this progeny of cases is about intentional tort. You have to have committed an intentional tort with knowledge that harm to plaintiff is likely to result in the forum state for there to be personal jurisdiction. So then the next huge case and new analysis style called the sliding scale analysis came about in the Burger King Court versus Rudziewicz 1985 case found that Florida had jurisdiction, Florida being where Burger King Corporation was located, had jurisdiction to bring a diversity action for infringement against a franchise store in MI, the state of MI. Now, Brennan's contracts plus analysis A set forth that the contract alone is insufficient. Factors to consider are prior negotiations, which might have occurred or were signed in Florida, contemplated future consequences, terms of the contract, actual course of dealing, like sending your money to Florida. Purposeful availment. The defendant has purposely availed himself of the benefits, privileges of the forum state to justify that he should be held to obligations to be held to answer in that state. Foreseeability notice. The defendant can reasonably foresee being held in the court there. I think there was some maybe arbitration clause or something. And choice of law clauses actually have some bearing. Hopefully we'll go into that a little bit more, but I like how the contracts plus analysis seems to want the mind to go there. Now, Brennan also is named on this reasonableness and fairness test, and within it, sufficient context so as not to offend traditional notions of fair play and substantial justice. The 5 reasonableness factors is 1, the court must consider the burden on the defendant, interest of the forum state, 2, plaintiff's interest in obtaining relief, 3, 4, the court must also weigh its determination to the interstate judicial system's interest in obtaining the most efficient resolution of controversies, and 5, the court must also weigh its determination, the shared interests of the several states in furthering fundamental substantive social policy. So, going back to the table that I was talking about to analyze specific jurisdiction, I put all of that reasonableness, what are we calling it? Reasonableness factors. I gave 4 the burden on the defendant, the state interest, the plaintiff's interest, the judicial system interest, and 5 is like some fundamental furthering several states. I'm just going to say sovereign interest in furthering substantive, what was that? Social policies. And I'm going to attribute this now to Burger King. There you go. For your reasonableness factors. All right. There was also contract plus. So, how can I put contracts plus over here? Two analysis coming out of that huge case. Analysis of 5 reasonableness factors. In this fact set, the leftover argument about indemnification is not of interest to the plaintiff or the state of California and is best suited for Japan and China forums. Okay, so here this has to do with Asahi Metal, but I don't have it in the right place. The burden of proof shift. Once the plaintiff has proved that defendant purposely availed himself, then the defendant must prove the jurisdiction works in a reasonable burden. And then we talk about Asahi, which I already have. Tires under the stream of commerce, but the company had no idea, Japanese company had no idea the Chinese company was going to sell in California and lacked foreseeability. It worked a burden on them to represent themselves there. The Brennan test, the O'Connor test. The O'Connor test is more specific to this, whereas Brennan is awareness that the final product is being marketed in the forum state. So this is more like going directly to stream of commerce. The counter test is an intent to serve the forum state specifically and conduct evidencing that intent. It's actually kind of saying the same thing. But the general rule is that the minimum context in the forum state must derive from the defendant's action purposefully directed toward the forum state, right? But this broke down on the basis of reasonableness factors because the burden on the defendant was super high, unlike the state and the interstate judicial system interest kind of override. And even the several states in furthering substantive social policies, that all overrode the plaintiff's interest in obtaining relief because really America just didn't want to have bad relations with its international partners. And so one person can die without vindication if it means that the several states are not just dragging Chinese and Japanese companies in to defend themselves in the country. Moving on, J. McIntyre Machinery Ltd. versus Nick Castro. Targeting the U.S. as a whole rather than individual states was not enough minimum contacts for SCOTUS to uphold a New Jersey Supreme Court allowing personal jurisdiction over a company of the U.K. to answer for occupational injury sustained in New Jersey. The plural opinion mainly is broken into three dissenters' summaries. Kennedy rejects the Brennan approach and seeks to broaden O'Connor's approach regarding targeting the whole U.S. does not equal targeting individual states. There's Breyer's narrower concurrence based on existing precedents. And then there's RBG's dissent by targeting entire U.S., target all 50 states. So, like, this country in the U.K. produces some machinery that got to be in production in New Jersey by some way that is completely out of their hands. And Jersey was like, fine, let's hold them accountable somehow. And then all these Supreme Court justices were like, I don't think so. Because it's not just enough that machinery, that they sold 5 machines, 6 machines in the entirety of the U.S. And then they were resold among owners in the state. They're going to need a little bit more on the defendant's action in a particular state, I want to say, to give them jurisdiction, to give Jersey jurisdiction. So, Bristol-Myers Squibb's company versus Superior Court defendant failed to show jurisdiction in California is unreasonable. Specific jurisdiction exists only where events underlying lawsuit arise out of or relate to the defendant's contact with the forum state. Minimum contacts burden proven by the plaintiff. Substantial business interest, advocacy, research facilities, labeling, no marketing, sales, or employees. Minimum contacts proven by plaintiff, which shifts the burden of proof to the defendant to show California jurisdiction is unreasonable. And the reasonableness review of 5 factors, I just wrote like 1, 2, 3, 4, 5. But we know what they are. Right? Yeah. It's the burden on the defendant, the state's interest, the plaintiff's interest, the intra-state judicial system, and then the several states. Oh, this one's harder. The several states' interest in furthering fundamental substantive social policy. I just remembered that by memory. State sovereignty was a secondary issue to specific jurisdiction in this Bristol-Myers-Squibb case. The state interest first compared to Baez drug, which was marketed and sold in New Hampshire, but was distinguishable because the side effects were less severe. State interest then compared to McKinnison, California company, subject to cross-claim, makes it convenient to share fact-finding, reduce duplication of 34 different states where drug users were greatly harmed, and then substantive relief test. So the gist of what happened in this case was like there were some drug trials being run throughout the country, and like they pointed to one company, but they brought the action in a state where that company had like a little bit going on, even though it wasn't like their main headquarters and stuff. And it was a class action too, which made it kind of funny. I'm going to go on because it seemed like we just burst out of constitutional minimum context analysis to more of a specific jurisdiction and minimum context analysis. And without much warning. And personal jurisdiction, so like one of the parts here is personal jurisdiction based on internet contacts, and Young versus New Haven Advocate is another newspaper case where a Virginia prison warden was defamed in an article distributed in local Connecticut, I think, community newspaper, and lacks intent to circulate to Virginia audience and cause prison warden actual harm in the in his state where he lives, in among his circle. And thus, for the analysis, when a specific jurisdiction is based on internet activities, the party's online actions must be aimed at the state and cause harm, giving rise to a claim under its laws. The holding is consistent with purposeful availment requirement and also aligns with the tort element of knowledge. The contemporary approach cites a 2014 case heard by the Supreme Court of the United States titled Walden v. Fiore. We talked about it already. There's also a Zippo case. Just quickly transitioned into Zippo. Employed a sliding scale approach that is more restrictive than inset. So inset is another case. I recall, I just don't have a lot of that. Oh, no, it's the next one. Okay. Zippo categorized web-based activities as either passive, where there's no personal jurisdiction, active, when personal jurisdiction is appropriate, but something more needs to occur, which is probably the knowledge of the impact to the state by way of maybe an intentional tort. And interactive, which adds improvement for forum orders directed at a minimum contact, maintains website for sales in the forum. I forget what that means. And assign jurisdictional consequences to each in Zippo. So Zippo's got this new sliding scale for internet contacts. Now, Inset is less restrictive than Zippo. Inset gives us the traditional jurisdiction analysis regarding minimum contacts associated with toll-free phone number in the forum. And the circuit courts have embraced some form of Zippo. Alternatives, I should probably write down what that is. So going back to the table, what does that mean? Zippo for internet contacts. If I remember correctly, which I don't, so I'm looking it up. It said passive, active, interactive. I wonder what's the difference between active and interactive. Oh, fudge. Passive, active, interactive. All I do know is that there's no personal jurisdiction for passive. Active and interactive, that's something you gotta translate what I said into meaning. And for active, I'm saying jurisdiction is appropriate, but to something more. Interactive, I use a plus sign, improvement for forum orders, directed at contact, maintains website for sales in the forum. So I'm not really sure how to interpret that. Alternatives to specific jurisdiction. Get to a good stopping point and take a break. The brain's exploding. Jurisdiction, general jurisdiction is your alternative to specific jurisdiction, which refers to cases where the nature of the contacts are wholly unrelated to the cause of action, allows the defendant to be sued for any activities it has committed anywhere, even totally unrelated, and thus much harder to establish. Perkins is the case that gives us the definition of being at home in the state. I love this case. So back to my table, when I refer to general as being at home, I'm just going to write Perkins in parentheses. So what happened in Perkins was that this was during wartime, and the president of a foreign company worked temporarily out of his home office in the foreign state of Ohio. And his activities were actually really interesting. There was this mining company that Perkins was indebted to, brought an action in Ohio, and the court viewed Ohio as a formidable jurisdiction because Perkins was essentially at home in the state, even though the contacts giving rise to the cause of action occurred like completely in another country. Presence in forum state was systemic and continuous. Like, he was there, he took calls there, his paperwork and accounting was done there, and that was his home, considered his being at home in the forum state. Goodyear Dunlop Tires Ops SA versus Brown. Parents of a North Carolina soccer student's team that was harmed and died in an accident overseas and enjoined German, Turkish, and French companies to answer for this wrongful death negligence claim, like that occurred, I believe, on a bus. And there was no jurisdiction for that. So part of the fairness prong that really mattered there was like, or maybe even arose from this, was like, is there relief? Is there still going to be relief for the plaintiff? So it's kind of like the plaintiff's interest available to the plaintiff in another forum. And I didn't really write anything about that yet, so it might have actually very well came from this case. That expanded perhaps on the plaintiff's interest. Daimler versus Baumann. Defendant's Argentinian subsidiary caught up in money laundering claim that occurred outside of California, but the presence prong, principal place of business, principal headquarters, such continuous, systemic, and voluminous contacts were so substantial to consider the corporation to be at home in the state of California as a de facto headquarters. Even though, like, their contacts in California had literally no idea what was going on with this money laundering. Like, they're completely not involved in this money laundering scam. Whether a foreign corporation's affiliations with the state are so continuous and systematic as to render it essentially at home in the forum state, all-purpose forums are general jurisdiction. All-purpose forums for general jurisdiction are a corporation's place of incorporation and principal place of business. Cool. So it's kind of like Perkins Part 2. But it also kind of then talks about the place of incorporation and principal place of business, which is like actually the Federal Rules of Civil Procedure names that as your domicile. So that's like this case's posture in the space of civil procedure. I got a couple cases just named here for general jurisdiction. There's Tambro versus Dworking. There's Frazier versus Smith, which was, I just have in parentheses, persuasive. Metcalf versus Renaissance, substantial. Doe versus Unical, substantial. And so, again, finding general jurisdiction requires substantial continuous and systemic contacts. Power over property. So this is the last short little subsection on obtaining personal jurisdiction is in rem and quasi-in rem jurisdiction, likened to the concept of property as a source of minimum contacts. In rem jurisdiction, legal action directed toward property, real or personal, rather than toward a particular person for the purpose of adjudicating the rights in that property that are conclusive against all the world. Quasi-in rem jurisdiction, type of personal jurisdiction exercised by the court over an absent or non-resident defendant who owns property, real or personal this time. I don't know, real or personal in rem jurisdiction as well. But the difference being within the jurisdictional boundaries of the court is where this real or personal property is. A quasi-in rem action determines the rights of a person in a thing rather than the rights of the world in a thing. whereas in rem jurisdiction is for the purpose of adjudicating the rights in that property that are conclusive against all the world. And like, I can't help but just define this based on the examples. So the example in rem jurisdiction is like quiet title. It's almost the, was it Pennoyer? I feel like it was Pennoyer versus Neff. Where like, we have your stuff, therefore we have jurisdiction over you. Quasi and rem was like a car filled the gas tank with like illegal money or something. And if you're the owner of the car, like, you need to answer. I don't remember why that. It's not even written here. So anyway, Schaefer versus Heitner. Shareholders derivative suit sought to bring shareholders to Delaware to answer for criminal contempt and antitrust action. Theory of jurisdiction was based on quasi and rem treatment of stocks that per Delaware statute have a situs in the forum state. All assertions of state jurisdiction, including in rem and quasi in rem actions, must be evaluated according to the minimum contact standard for fair dealing and substantial justice. Jurisdiction will be sustained only where the interest of the person in property seized has sufficient minimum contacts or relations to the state. In dissent was Brennan that the state interest to hold officers accountable to rules that brought company into existence. Minimum contacts are the requirement, not to be confused with or as opposed to a standard for best contact. And those who concurred with the opinion, starting with Stevens, said quasi in rem jurisdiction, power to litigate, too much risk of judgment without notice. Powell concurred as well, reserving certain types of property. And then the significance of Schaefer versus Heitner is that there's significant changes for quasi in rem jurisdiction, not significant for in rem cases. And before I get to this last point, I'm going to say clearly the conclusion was that this shareholder derivative suit brought to bring shareholders to Delaware to answer for criminal contempt in an antitrust action was not proper quasi-personal jurisdiction. And mainly it's just because Delaware statute set was specific. But then all these Supreme Court justices were also like, yeah, blah, 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 blah. In rem jurisdiction, in cyber squatting cases, that's the next case. Harrods Ltd. registering another trademark is outlawed by ACPA. In rem allows the plaintiff to litigate because of state interest and related minimum contacts. Next section. Oh my God, it's the same section title, alternatives to specific jurisdiction, but it's talking about transient jurisdiction consent. It's talking about getting consent from form selection clause and choice of law clauses. And then we'll talk about service of process. So this is the last page. So for transient jurisdiction via service on non-resident defendant within the state, it's also known as tag jurisdiction. Burnham v. Superior Court, where the defendant is a New Jersey resident served in California for divorce proceedings from ex-wife or by ex-wife. The defendant, not the plaintiff, brings an action against the Supreme Court for denial of motion to quash for lack of personal jurisdiction. I'm pretty sure this was by fraud. Like, for instance, he was in an airport on another, like on a fraudulent, somebody brought him into an airport just to serve him or something. The plural opinion has no precedential effect, but dissent opinion allows tag jurisdiction okay for national persons, even if entering California to be served for divorce in this case is unfair without more, because defendant could not enjoy fruits of forum state, for like a day. And fruits of the forum state include the economy, safety, physical security during the 4 days of his personal visit. So they call it benefit and protection of like state laws or something. Scalia Pennoyer is a time-honored approach to creating personal jurisdiction based on physical presence alone, forming contemporary notions of due process. So Scalia's got the right opinion, as always. Brennan is saying due process and minimum context reach the same result. Ultimately, the court did not view Schaefer as overruling Neff, evoking fair dealing and substantial justice. So, thus, tag jurisdiction is not often applied to corporations. That's coming from because this is like not even a corporate case. Consent jurisdiction, international shoe repudiated implied consent, but actual consent is still a valid jurisdictional basis. Forum selection clause. Court is identified by the parties in the contract for related disputes and prevents personal jurisdiction. Choice of law clause. Contract identifies law that will govern disputes that arise under the contract and is silent on the forum. So that's just a definition of what these things are. Although it sounds like a forum selection clause has an effect on jurisdiction. The choice of law clause is identifying the law to be applied, but not affecting the forum. Forum selection clause example comes from Carnival Cruise Lines versus Shoot. The holding, this is a 1991 case, the holding is a consent to jurisdiction prior to suit through forum selection clause, and such agreements will ordinarily be binding and enforced by federal courts if consistent with fundamental principles of fairness. Oh my God. Okay, consent in other contexts. State registration statutes is a muddled area. Consent by estoppel, I don't even know anything written here. Corporate consent, personal service on attendant, Ratcliffe versus Cooper Labs, and PA Fire versus Gold. So I'm going to take a quick break, and we'll come back and talk about Rule 4 from the Federal Rules of Civil Procedure. Service of process. I don't even know if I want to read service of process because it's just rule based. Okay. And it goes on for like 3 pages. Then we'll get into diversity, federal questions, supplemental, and removal jurisdiction. Which all of this is rule-based. It's not as much of an analytical-based, application of constitutional principles. Like, there's actually rules. I know them all, at least for this fall semester, about service of process. What is process? What is service? Subject matter jurisdiction. What does that include? Now, I need to memorize the rules it looks like, a couple issue spotting or buzzwords that come from this section is the well-pleaded complaint, from the quote master of the complaint rule, and the artful pleading doctrine. So I may read that. Well-pleaded complaint rule makes plaintiff the master of the claim. She may avoid or invoke federal law. She decides which laws apply. The artful pleading doctrine limits shopping that is inherent in allowing the plaintiff complaint to dictate federal question jurisdiction, and provides the plaintiff with the ability to form shop, and thus is probably not effectual. There's this Grable standard that I have highlighted here. So what does this mean? Does a state law claim necessarily raise a stated federal issue actually disputed and substantial, which a federal forum may entertain without disturbing any congressionally approved balance of federal and state responsibilities? Your analysis answered that question implicating federal issue is A, state action based on federal question jurisdiction can be taken if prong 1, it meets substantial federal interest test, which can be determinative with and allow one to skip prong 2. Prong 2, I want to say this is probably a disjunctive test, therefore, is consistent with congressional judgment. Is the action, right, or is the question, federal question, consistent with congressional judgment about the sound division of labor between the federal and the state courts? Federal question jurisdiction after Gramble, it appears there was a narrowing of this Gramble standard in by Empirical Health Choice versus McVeigh, Gunn versus Monitor, and Calic versus NW Airlines, and Budget Prepay versus AT&T. So then we get into some supplemental jurisdiction, pendant and ancillary jurisdiction after Gibbs. Some of the things that I could really take from this are, like, at least the sections prior to this point is amount in controversy, definition, domicile. I think I'm fairly well versed enough to attack the bar based on what I know or can set forth on paper. So, like, I'm continuing to walk. Before I walk directly into supplemental jurisdiction, and I think maybe I will expand by giving the rule for supplemental jurisdiction and federal removal jurisdiction. Maybe I'll just pick up with those two sections in another reading, but I did want to briefly go back to brush up the language that I'm going to be using on the bar. Ooh, there's Mullane. Mullane versus Central Hanover Bank. New York statute allows an appointed attorney guardian who represents remaindermen and commingled trust plan places in newspaper of pending action against the trustee to which the remaindermen have an interest. And the newspaper notice fails constitutional due process because some of the remaindermen's addresses were ascertainable and therefore notice was inadequate. And okay, so when you're talking service of process, know this, that the notice must be reasonably calculated under the circumstances to inform known parties affected by the proceedings. Expanded upon by Dusenberry versus U.S., which was the policy of the prison to deliver certified mail, and then the Jones versus Flowers case where you're trying to hold a tax sale and you know that your mail is being returned. That's not, quote, notice reasonably calculated under the circumstances to inform the parties of proceedings affecting their interests, which you call apprising the interested parties of the pendency of an action and afford them the opportunity to present their objections. So that's the main point of service of process. Clearly, process is the summons and the complaint. Service on individuals. I know this, that the U.S. District Court follows the laws of the state for service where the suit is pending. That comes up in a million MDE questions. Service on entities. You got the registry agent. Fine. Service outside of the U.S. Rio versus Rio. Now, Rule 4F tells you that if you're serving a company outside the U.S., you can do so per international treaty. If there's no international treaty, per the foreign country's law, or as the foreign authority directs in reply to a letter of rogatory from the U.S. court or individual, or hand delivery or mail that requires a signed receipt. Then there's a catch-all: by other means not prohibited by international agreement as the court orders, and that's the rule. Looks like I've got this page marked. All right, 4F. Do I have the, I wanted to mark that Moline. Moline. God loves Moline. The central bank. Where are you? Why do I have it here? I've marked it here. National contact, not minimum contact. I don't know if that's I'm taking up. Again, the purpose of this, go over the last 9 minutes of going over it, is simply to brush up the skills on how to speak about, 1, notice must be reasonably calculated under the circumstances to inform known parties affected by proceedings, apprise interested parties in the pendency of the action, and afford them the opportunity to present their objections. That is from Mullane. Notice reasonably calculated under the circumstances to inform the parties, to apprise the interested parties, to inform the known parties affected by the proceedings, or another way to say that, apprise interested parties of the pendency of the action and afford them the opportunity to present their objections. Dunsbury, Jones came after. Rule 4F, this will probably not come up. Maybe MDE questions is, if you're serving outside the U.S., do it according to international treaty. When there is no international treaty, 1, foreign countries' laws, or a letter of rogatory is sent by your court to the foreign authority, and the foreign authority directs the U.S. court the best way to serve process. Or lastly, by catch-all, other means not prohibited by the international agreement, which is treaty in the earlier parts, and or as the court had ordered in that last example. There's waiver of service provisions. Email service is not permitted. And moving on. Unless they expressly like accept service that way, like consent to email service expressly again. And then if you waive service of process, you do get more time to respond, 60 days, domestic 90 days, international. And what is the usual time in which they must respond? I want to say it's 21 days, but I'm going to get to that in the spring semester outline. All right, so federal question jurisdiction, we talked about the main points, right? Is that the master of the complaint and the artful pleadings and the well-pled complaint. That's all well and good. For diversity jurisdiction, there's some finer points that matter. And I've got them all highlighted. I'm a genius. All right, so in diversity, you need complete diversity of citizenship. For individuals, what is their citizenship of U.S. citizens? Is that they're domiciled in the state? They can only have one domicile. Domicile is a residence and the intent to remain there. If someone moves after the time the complaint is filed, it doesn't matter per the time of filing rule. Children are incapable to form domicile. Corporations, however, domiciliary term came from the Hertz Corp and defined in Wachovia v. Smith is for chartered bank is domiciliary where the main office is situated. All right, but for everything else, there's one state of there's each state in which the corporation is incorporated and one state where the principal place of business is located at, which is defined as either the nerve center, according to the corporate acts test, the total acts test, or headquarters. Another way to say that is where, how I've been saying it, is that all of the corporate executives make their decisions there. Alienage jurisdiction. Language is broad enough to allow aliens to be additional parties on both sides of the dispute, but requires at least a U.S. citizen on both sides. That was recently came up in an MBE question, which is why I'm reading it now. So what that means is that you can't have a case that's an alien versus an alien in the United States. You can't even have an alien versus an alien plus a United States citizen. There must be a U.S. citizen on either side of the case. That's what that means. Aliens cannot be adversaries without right. U.S. citizens on both sides of the case. Where are aliens located, though? What is their domicile? I want to say it can be any state. Forget. And this is what I want to find out. Permanent resident aliens. I feel like aliens could be any state, but permanent resident aliens, for purposes of determining jurisdiction of a permanent resident alien, is not a U.S. citizen and cannot support federal jurisdiction against a foreigner alone without a U.S. citizen. In contrast, between states, the alien can create diversity jurisdiction, however. Statelessness destroys diversity jurisdiction. Stateless means that a party is not a U.S. citizen or a citizen of any other country. There is no federal diversity jurisdiction for a stateless person. And this basically is a term for Native American tribes. Okay, well, all right. Mountain of controversy is the last thing that I wanted to wrap my head around and fine-tune the verbiage on, which one Amount of controversy is the second component of diversity jurisdiction. It requires that the action exceed $75,000 and legal certainty that such amount is attainable is literally all that I wanted to take out of this language. As it pertains to punitive damages, I mean, I really feel like it's the same. There must be a legal certainty that such amount is attainable. If you're in a jurisdiction that says there's absolutely never going to be punitive damages for said cause of action, then it cannot be part of the amount in controversy in order to exceed the $75,000 requirement. I have highlighted what anti-aggregation heading. I'm referring to a table on page 218 of my book. But what it says is there's some exceptions, but the anti-aggregation stands for even if factually related, multiple plaintiffs may not aggregate separate, distinct claims insufficient to reach the amount in controversy. 1, a single plaintiff may aggregate against a single defendant. A single plaintiff may not aggregate against multiple defendants. And multiple plaintiffs may not aggregate their claims together. Exceptions here are that multiple plaintiffs may aggregate their claims if based on a common undivided interest, permitted where one party aggregates its claims against another party, permitted where multiple parties assert claims based on one common undivided interest or res that exceeds $75,000, permitted where plaintiff asserts claims against multiple defendants based on joint and several liability, and joinder by Rule 20 in Chapter 7. So we'll get to that. It sounds like, class actions are going to be its own thing. Joining those, right? Talk about that. That's all second semester stuff. So I officially just brushed up on all of the information I needed about service of process, and notice. And what kind of notice again? From Mullane, what is the notice? Remember this. Reasonably calculated under the circumstances to inform the parties affected by proceedings. Reasonably calculated. Got that international service. Okay, we got the diversity. Language for that is legal certainty that such an amount is unattainable. We kind of got the idea of what aggregation means. Aliens. Most don't even care what state they are, but they can't be on both sides of the complaint. Master of the complaint, artful complaint, for federal question jurisdiction. The other two types of subject matter jurisdiction is supplemental jurisdiction. Claims that do not fall within original jurisdiction of the federal courts by diversity or federal question can, if certain criteria are met, piggyback on a qualifying claim into the federal court, but it's discretionary. Another way to refer to it is pendant jurisdiction. This requires that the plaintiff claim has a common nucleus of operative fact from GWIBS. There's a statutory authority for this. It's section 1367A, which talks about the cumulative common nucleus of operative fact. 1367B only applies to diversity, not federal question jurisdiction. This has to do with the plaintiff's qualifying claim in diversity. I am not even gonna go there because it's really complex, and I might be able to understand it now that I've taken the whole class. At the time, it was like crazy, and what I've noticed is that the bar is totally not entering into that category or territory. So, Alipata, that's written here. Cool. Love ExxonMobil versus Alipata. Wait a minute. If this has anything to do, I thought that, okay, we go to Alipata again when we're talking about the Erie Doctrine. So as it is standing here for relevance to the supplemental jurisdiction, I'm going to skip it. For removal jurisdiction, definitionally, if requirements are met, federal statute allows a defendant to remove a case from a state court to a federal court when the plaintiff files in the state court a claim that would otherwise qualify for federal jurisdiction by diversity, federal question, or supplemental. So that's the other definition Erika needs. Again, there's a statutory section on this, section 1441. And for subject matter jurisdiction, I think I am good on those concepts. Defendant unanimity rule. I think what that means is everybody must want to go to a federal forum, like all the defendants, it is. Class Action Fairness Act. Okay, so we do talk about class action in the end of the first semester. What needs to be known about class actions ahead of the bar? Talked about venue in the first semester. And forum non-convenes. Standards of venue transfers. I might want to look at that. Maybe even the law. If it was an improper venue, I've got this so memorized I don't really have to read it. In Erie. So in the next recording, do a light, broad stroke touch to get to fine-tune the language that I use to describe the following. Class actions, venue, when it's proper, when it non-convenes, what law applies at transfer, and the Erie Doctrine. I'll reread the Rules Enabling Act note card that I have. But that will cover in the next recording along with what we learned in the spring semester.